All right, it's 5:30. We're ready to conduct business here. Madam Secretary, would you please call the roll?
All right. Janice Brothers here. Wayne Hart. Here. Whit Lee.
Here.
Kenneth Reed. Here. Greg Vick.
Here.
We're all here.
We're all present and accounted for. Ready to conduct business. You have the June 18th, 2026 meetings minutes. What's your pleasure?
Move to approve.
Motion by Brothers. Second by Mr. Hart. All in favor? Pass unanimously. Have a motion to approve the agenda.
Move to approve the agenda.
I would note that item C has been withdrawn on the agenda.
Noted.
Noted. All in favor? Aye. Pass unanimously. We now. He made it first. Commissioner Brothers second. I apologize. I didn't do my job.
And in my motion, I noted that C was being withdrawn.
Okay. All right. Public comments. We have two, Ronnie and Edith Greenhagen and Brandon Heath. You're welcome to speak now, or if you want to wait till your item comes up, you can speak then, and that might give you a little better time if that's agreeable. That's y'all's choice. Okay. All right. But we always let you speak, but want to make sure it may be more appropriate then. All right. New business. Curl Properties LLC on 4th Street, Bell Buckle. Tax map 038J, parcel B 003.01, 0.35 acres more or less. Applicant requests variances to permit the construction of a single-family dwelling as shown on the site plan. And I'd remind the board, this is in the Ransom-Stevenson edition. These are lots of record that go back to the late 1890s, early part of the 20th century. And these lots are a mess. There's nothing to do, but they are lots of records prior to zoning. I wanted to remind everyone of that. Staff.
Yeah, the Curls are asking for a front setback variance and a side setback variance. In your packet, you should have on the second page a shrunken version of the survey, and there's a gentleman here from St. John Engineering who can, if he has a larger version of it with him, could pass it around. But you can see on that survey that there's a building footprint for a home at the bottom south side of that. So, and as you guys look at this, you'll see that the building footprint is to the south of the lot, and you can also see a power line easement that runs west to east in a diagonal fashion, and what that's doing is constraining the lot's ability to build a house on it. And if you'll also notice, probably to the northeast of the lot, you'll note that there's not enough room there to build pretty much anything. And so the only place they can build is where they've shown it. And because of how the power line easement runs diagonal to the south, it's going to push the house closer to the front setback. And so we feel like, the staff felt like that it was a good mix of what they chose to ask for as a side setback and a front setback, because it kind of evened it out a little bit. And also, kind of infer when you look at the houses that are in the area, that not just the Ransom-Stevenson subdivision, but also the Oakwood subdivision, which is a Bell Buckle municipal subdivision, which has very small lots in comparison to what we would have in the county. So it's really not out of character for either of those subdivisions, either the modern subdivision that's a municipal subdivision, or the old antiquated Ransom-Stevenson subdivision, which has all those shotgun style lots. So the variances they're looking for is a 27-foot variance on the front, which leaves 23 feet out of 50, and a reduction on the south side from 25 feet The 16.82 is a 8.18 feet variance. And we
May I
got,
ask you a question, Mr. White? There's no special circumstance that's unique to that, is there? Just the irregular formation?
I don't understand the question.
It's a small size, irregular configurated lot right there. So is the special circumstance unique to this lot, but you're saying it's not, that they're all in various sundry locations throughout this whole area?
Well, I have this pulled up. Let me show you. I'm going to stand there for a second.
Oh, prior to that, probably 2000,
Okay.
2005.
So these lots, I mean, like a lot of these houses are 15 foot from the right of way anyway. So not much, I mean, actually less than what this application is asking for on the front. This person, we got a phone call just out of curiosity from him. I addressed answered his questions, and he was fine. They're not against it. This person sent in an email, which was actually against it initially. And when I addressed it, what I explained to her, this is undeveloped. This is a half-acre lot. This is a 0.35 acre lot, thereabouts. But when you once you take out the power line easement, it reduces it to a 0.2 acre lot, what's available to them. So it's small, like the other lots we talked about, but it is different in that the power line easement constrains it even further. And once I explained to this person that if they ever want to build a house, that power line easement affects them in a very similar way, they would probably need a variance just like the Curls are asking for. So once we had that conversation, they sort of understood it better. The other thing is, by pushing this house more forward and further south, it actually has no effect on, actually increases the distance from this lot. So it actually really has no impact on them whatsoever. But once we sort of explained that they would likely need the same variance, then they weren't didn't have any problem with it after that. But we wanted to show you, like, this lot, this is 50 foot wide. These lots are 50 foot wide. There's a lot of really irregularly shaped lots in here that we're just living with, that in some cases are not even really buildable. And some of these lots, like this one tonight, could not be built on without the variance. It just cannot be. It can't be built on.
So they've met the
following
burden,
our
they've
rules.
met the burden of proof of the site being unique
Yes,
in its
we
dimensions.
feel like they have.
Now you also have your replies to two, and I believe that the Lightborns. Yes. And their concern, and we need to make sure that that goes into the record as well. And I think you have two, one to Tiffany and one to Mary. Is that correct? Are they both the same? And I think that's in all y'all's packets.
Yes, and there's some correspondence back and forth here.
Okay. Mr. Greenhagen? Now, is this item you wanted to speak on? Yes. Okay, all right. And what are your concerns, sir? And if you would, step up to the mic. If you're not able, sir, you're welcome. We'll bring the microphone to you. And if you would, identify yourself for the record, please.
Well, I hope this microphone works a lot better than those do. My name's Ronnie Greenhagen. I live in the property just south of that lot that the Curls have purchased. Okay. Oh.
That's where you reside?
That's where- yes, sir.
Parcel 21.00. Okay,
Yes.
just immediate to the south. Thank you,
Right.
Mr. Go ahead.
Okay. I'm not sure that I should speak here. I'm really not against them building a house on that lot. As a matter of fact, I welcome it because it would improve my value of my property. I was surprised, though, that they purchased that lot to build a house because it is so small. And they cannot go where the power lines are. And so they have to come this way. And I accept that. But I think it's a little strange that it would cramp everybody in our neighborhood. My lot's much smaller than that one, and perhaps smaller than any in that neighborhood. But so we feel kind of boxed in anyway. And but we feel like if they can build a house and it becomes 16 foot there, we don't have a problem with it. The big problem that I have is our fence line that goes between those properties. According to the survey, the survey that had most recently been done, my fence, back corner of my fence is about 6 foot across into that property that Carl has bought, if that is correct. Also, the property on the south side of me is in the same boat. They've got a fence that goes down their property, and it's about 6 feet or so over into mine. And somewhere along the line, somebody made a big mistake, and I understand that. And I just wanted to give a little reservation, not necessarily the house, but how these things are surveyed and why it is that way.
See your survey again, please. And again, but
I've got one too.
that concern and these lines do get skewed. It's hard. A lot of this is where you start. Now, I want to make clear, you are in, I'm going to call it the new subdivision that was developed within the last 20 or so years.
Yes, our house was
okay,
built in
yes.
2015.
Okay. Is
Is that right? 2015. Yeah.
It's showing an encroachment on the survey of 3.9 feet. Your fence is on his property, 3.9 feet, according to the survey.
My fence is on that property that much.
Yeah, they found
Yeah.
an iron,
I
they're marking
measured it
it.
about 6, but different measurement, I don't know.
Well, that's, but
It's just the corner. Yeah.
yes, it
And
shows
there's a
here
different
where it's-
angle than what I suspected it to be. It's actually about 12 feet from where I was told the property line was,
Okay.
but it's actually only 6. So I don't know what the Curl properties would think about, you know, what I'd have to do or what they'd want to do or what. I have one right here. Oh, you have one? Yeah, I've got this one. But I don't have that. Yeah. This is where I'm talking about there. Our fence goes right along here, but back there, I don't know what that X is about.
That's the fence. The X marks.
Yeah, so that's showing 6 feet. Yeah. Okay. Yeah.
That was for the original survey of Oak Haven, whatever.
They were actually surveying according to an older survey that they had. They got it at the courthouse. They did not have this updated one, the surveyors. And so I went out and see what they were doing, and they told me, and I said, well, I've got a survey that might help you. And I showed them this survey here, basically. And they found the pin.
Okay.
But they couldn't find it without this survey recently.
Well, main thing is you're comfortable except for the corners, and that's something for the surveyors to argue, you know.
Yeah, right.
And again,
Right.
that's
Like
not
I say,
unusual.
I'm not sure I'm supposed to be here or not. So.
No, you're doing fine. Thank you, Mr. Grant. We appreciate it. Anything else?
No,
Okay, thank you, sir.
I'm not opposed to the property or the house being there. I'm just worried about the survey and the reality of it, if it's
Yeah.
really true.
I guess we'll have to, do you remember who the original survey was by?
Yes, it was someone in our office. It's Aaron Yielding.
Thank
So
you,
I
Mr.
didn't know if they were gonna ask me to tear my fence down, or,
That's
didn't know
something,
if
again,
y'all
that's
had
something gonna
anything
have
to
to
do
be
with it.
between the surveyors and your new neighbors of building the property. And that's, again, I would say since we've got a survey within 20 years when they did, is it Oak Haven? The name of- Oakwood, that survey should be recent enough, even though it's not, probably not GPS marked. It's probably recent enough that they can come off and get pretty close.
Okay.
And you and your neighbor on the other side are gonna have a fence issue perhaps.
I'm not even gonna, it doesn't bother me a bit, so, you know. I'm just hoping that it won't bother the curl too much to do that.
I imagine if they get their house built, they'll be satisfied. Okay, thank you, sir.
So,
Okay.
Mr. Chairman, I will move that the reduction of the required front yard setback from 50 feet go to 23 feet, a variance of 27 feet, and from 25 feet to 16.82 feet, representative variance 8.1 feet. I'll make that motion.
I have a motion by Commissioner Vick.
Second.
I have a second by Commissioner Brothers. Any further discussion? Y'all ready to vote? All in favor?
Aye.
Pass unanimously. Ms. Watts? Caitlin Watts, property address 620 Pinkston Road, tax map 042, parcel 058.05, 3.2 acres. Zoned A1 agricultural, request a special exception approval for a one-bedroom, 716 square foot accessory dwelling guest house located approximately 200 feet behind the dwelling. Staff.
Yeah, I mean, it meets all the criteria. We've looked at, 716 square feet is small in comparison to most of these things. It's a one-bedroom, guest house, used for, as guest accommodations and, not rented. They've included a septic permit issued by the Tennessee Department of Environment and Conservation for a one-bedroom residential structure. So staff's fine with it. It meets all the criteria.
Mr. Heath, are you here representing? Yes, sir. Okay, all right, we've got you on the speaking, all right. I thought that was a sign-in sheet, so. That's good, that's good. All right, what's the pleasure of the board?
Move to approve.
Motion by three, second by Mr. Hart. Ready to vote? Any further discussion? All in favor?
Aye.
Pass unanimously. Thank you, sir. Item C, Andy Watley has been withdrawn. David King. All right, I'd like to point out, and I think you've got in your minutes, we had the timeline that was outlined of this from approximately of August of last year. And I think you also have a pretty good sized packet that, I believe this is it, that Chris, the staff has enclosed. And if y'all want a few minutes to kind of go through this and make sure, on advice of Ginger Schaffner, we thought that we're going to try and include all of the items from our original hearing for Mr. King into the record, so we get a complete record of what was occurring. Now, I'd like to also point out that Ms. Tamara Smith is here to represent Mr. King, and I think she's also had the packet in her hands as well, so she has the same packet. If y'all want to take a minute and I say just hold a second, let's look through the packet and let everybody get a good feel that you've got it before we get started.
May I ask one question first?
Yes, sir.
This is, for staff, this is a complete and total package of everything in the record that we have in our files on this. Is that correct? There's nothing missing, no correspondence, nothing. Everything is complete and total, and we have it in front of us and have everything we've done and said on this file.
That's correct.
Mr. Chairman, I would like to bring up one item.
Yes, sir.
In terms of Ms. Tamara, she has requested copies of all of the items relative to the passing of the resolution itself, when the Duck River overlay was passed. And we have been doing an autopsy on our records, because there was a number of times where in the planning commission stages, this was worked on for quite some time. It looked like to me and in the minutes of a lot of those meetings, there's not a lot of specificity. So it's been really difficult to rebuild it. And the planning commission passed it to go to the county commission at a particular time, and then it would seem like it was maybe 2 months before it actually went to rules and legislative rather than one. And there was just all these things that have confused, because there were several different overlays being passed at the same time in the same time period. So we've not got her the complete record in terms of all of the records pertaining to the passing of that resolution. But as far as what's relative to Mr. King's case as terms of the documentation or whatever for the 3 meetings that he attended here in the BZA, yes, you have all those records. But she still is due some different records that she's requested. We're just, again, trying to do a bit of an autopsy to try to make sure we get her the exact thing, because we turned in some things to her that turned out to be a different zoning overlay.
But
And so-
everything that we've had for this board is included in this.
That's correct.
Okay.
So your statement is staff, and I'm putting you over on planning commission. We will provide that. Staff will provide that.
And
It's-
really, that, those comments by Chris is a perfect lead-in to what I intend to present to you all tonight. It's not a rehash of what was done back in the late summer and fall of last year regarding the condition of the lot. I believe Mr. St. John was involved in that. And at the conclusion of a hearing in October, I think the conclusion was that the lot was definitely constrained. I think the conclusion was that the dwelling was built in about the only and or best place for it to be built on that lot. And I believe the motion that was made, is that it would be denied, the variance would be denied due to the lot being constrained and the hardship being self-imposed. So I really don't want to revisit the issue of the lot being constrained. It is the hardship being self-imposed that I intend to spend my time talking about. And that does require us to look at whether or not the public in general had knowledge that the Duck River overlay was going to be passed, and most particularly and specifically the people that live along the Duck River. So Mr. White has worked with me quite diligently to get to me what he remembered existed and knew existed. In order to maybe move that along a little bit, I did present a records request to Mr. Daniel, and I've received a few things, but none of them, as Chris said, specifically talked about the Duck River overlay. So that's the focus of my argument discussion before this board. So if we don't have records that we think actually exist, you know, we can bifurcate this if you all think that is the best thing to do. We've been looking for these documents for several months, and my argument would be that Mr. King didn't know about the overlay and probably didn't have any reason to know of the overlay because of how it was published and handled. And not here to point fingers or cast aspersions. My point, I guess, is that if we've been looking for these records and notice of publication and notice of things that landowners are supposed to know about for several months now and can't produce them, then how would Mr. King have known to be watching for some publication to appear in the newspaper about the Duck River overlay? So that being a big basis of my argument, I will rely on you all to tell me whether we should proceed tonight or whether we should see if we can find records. I know that Mr. King is anxious to move forward. I have argument and discussion for you. There is an issue that he particularly has asked to speak to the board about, and I will, as his attorney, I will certainly let him do that. But he and his discussion will probably be a little briefer than mine. So, I yield to Mr. White and to this board about whether or not we should move forward tonight.
Thank you, Ms. Smith.
We would like to, but if there's records that are missing and we're gonna have to come back and do this again, I'm not sure that.
And that's, I think, let me remind the board, the time for a normal appeal of our initial decision is well past. So that's out, and I think the appropriate action, what we're now faced with, is and I think within 6 months of the denial, they had the right to come back and apply again. So I think that's where we are now. We wanted this part of the old to be there, so we didn't have to go through all of that. So, but the main thing is we'll handle this as a new variance, and that starts, and I'll use the word, that starts the clock again for if they're not happy with our decision, or if the next step would be a judicial review. And if I remember our discussion from, and having trouble remembering what I had for breakfast, but I think if I remember the discussion, our decision was based on, we were placed in a situation, I think we did rule that it was constrained, but we also ruled that it was something of his own making by not doing the permitting process. And we had no course of action that was open to us to issue a variance. I think that was, if I remember our conversation, that was the gist of what we saw no avenue open for us, which I think the law allows at that point. You're open to judicial review and judicial relief, and that's the way it should be. So if y'all are in agreement, then we'll start this as a new variance and just start it like we do normal things. And I appreciate you pointing out the points you're going to make. We might skip some of the topographical stuff, may not have as much variance given your research and argument. But that's it. So is that agreeable with y'all? Any comments? Anything you see where I've left a hole here?
The only concern I have is everything that this committee has looked at is included in this package, and we haven't seen anything outside of that. That wasn't part of our responsibility. This is our responsibility, and our decision was made because we're constrained in the decision we can make. It has to meet criteria. We can't, there's no leeway for us. It either does or it doesn't. And so we met our burden on that. As far as the Duck River situation, I mean, we didn't have anything to do with that. We just can follow the rules that we have right here. So you have summed it up completely there.
And if I remember from Mr. Sam, who gives those, in a lot of cases, I would point out issues like this, if something was not done properly, not by this board, but somewhere in the past with an adoption of a resolution was not done properly, that throws it, but that's where the judicial review comes in. And I want to make sure where we are and the information we have, so we know where we are. We're looking at a new variance. Now, I would entertain a motion. I'm going to read it in, and then I think we need to make a motion to include all this packet in the record so it's there for judicial review if that comes into play. And then we'll start all over again with staff, and then your chance, and Mr. King or yours, whoever y'all choose to speak in. Is that agreeable with the board? Does that sound like a reasonable approach? All right. Dave King, property address on Moonbend Road, tax map 044, parcel 021.02, 40 acres more or less. It is zoned A1. He requests a variance on this property. Staff.
Okay. So the first time we heard this case was on August the 21st, 25. And Mr. King showed up and he didn't have any legal representation. So I think at that point you guys essentially told him that without him presenting evidence, without anything contrary to what we had in front of us, you wouldn't have any way of doing anything other than a denial, and that you recommended that he accept like a 30-day deferment, and then that way he could have time to have some legal representation. So that's what he did, and on September 18th, 2025, he came back, and he had legal counsel, a gentleman named John Cooper of Holland and Knight attorneys. And Mr. Knight argued his case, and they brought some, I think, a drawing from Scott St. John, which was that plat, this particular plat, not the topos. The topos got introduced on the next meeting. That meeting, he was able to come back. What you guys recommended was that Scott St. John meet me and Mr. King out at the site so that we could look at it physically, walk it, to see if the characteristics of the topo map, you know, what that looked like in real life. So I went out there and walked it with him, and when my report back to you guys was essentially this, is that it's probably one of the worst pieces of property I've ever seen. There was crevices and sinkholes scattered everywhere. It clearly is a place where a lot of underground water moves to the river, and so there is a lot going on. And so essentially what I asked Mr. King to do was, there was one area on the topo map that we identified actually in the meeting, just looking at it, and I said, that looks like maybe the one bright spot on the entire parcel. So I was particularly interested in that. It was a little plateau area. It was relatively flat, and I didn't see any indention, any karst activity or whatever on the topo itself. When we got out there, once we sort of realized it was a horrible piece of property in terms of, if you're looking at it, you know, for development potential, I wanted to see that specifically, and so and Mr. King helped me find it. And we got it, and it actually physically did look like it could have been a suitable site to build a house on. Wasn't directly on the river like he would have wanted, but it wasn't too far. And so my advice to him at that moment was, if you want to prove that this site is constrained, completely constrained, it would be valuable to you when you come back. I mean, this is a shot that you're trying to take to try to get some help. I recommended that they do some geotechnical investigation on that area, because my guess is it was probably constrained as well. We just couldn't see it because there's so much water movement on the property above and below ground. It's very clear. So, but to prove that, I felt like it would have a stronger case before the BZA if he were to do the geotechnical studies. Did not do that. And when he came back the next meeting, also he didn't bring his legal counsel there, and so they wasn't really able to put on any evidence or any change of circumstances. The other thing that I think that maybe wasn't particularly noted in the meeting was that we talked about on the site was this, and that is, because he didn't get a permit, because he didn't hire an engineer on the front end, there's really no guarantee that the site that he built the house on is not constrained equally. There could be underground caverns right below it as well, and he wouldn't even know it. That's just where he chose to build it. And to address Ms. Tamara, what I would say is this, is based on what the record I've been trying to put together for her, I'm just trying to make sure, because we gave her records before that weren't correct. And the reason why they weren't correct is because it's hard to identify visually because of the language that's in the minutes, not necessarily what occurred. And I'm having to listen to all of these audio tapes, and some of these planning commission meetings are over an hour long, and so it's just, with the amount of time, it's just going to take me a little bit more time to identify the exact record, to make sure that when I give it to her, it's the right thing. Because, and then what we'll do is also give her the audio files of the meetings to prove that those are the correct minutes. I just don't want to get it wrong again, but I'm confident that we can give her the records. It's just, this issue is a little different, because when we, normally you want a set of minutes for a particular meeting. Well, this meeting got put off arbitrarily, and then, so it came on a different time, and so that confused Blake when he was putting the records there the first time. So there was just a lot going on. So I'm having to listen to these audio tapes. And so, or they're not tapes, but digital audio files to try to make sure that I'm doing it correctly. And then the last thing I would say is there are zoning resolutions or a plethora of things that the county commission passes all year long. And most of us don't know about any of it. That doesn't mean that it's not fair or that it wasn't handled correctly. It just means that most people are not plugged into the process. Most people don't pay attention to what's happening at the county commission level. They don't look at what's advertised. Most people don't even get the paper anymore. There's a time period we didn't even have a newspaper. So, that is the reality of everything. What Mr. King would have known about that overlay if he would have just pulled a permit. That would have been the moment in time where he or literally anybody in the county would have been notified. Just like on 231 North, we have an overlay called the Shelbyville Gateway Overlay District, and it affects how properties developed along the 231 North corridor. The only time people know about that is when they want to pull a permit and build something and that's when we let them know that, hey, there's a overlay, and it has all these different characteristics. There's one on Bell Buckle Lane from 231 to Bell Buckle. I would venture to guess most people don't know about that. There's an airport overlay, and to some extent the airport overlay is what preserved the property that ended up becoming the MTSU Flight Center, what they're doing right now. There's a lot of things, there's a lot of different things that get passed, and it wouldn't just be that. It would be when the beer board decided to pass regulations that regulated beer. I would say 99.9% of the people in the county had no idea that it happened, but if you want to pull a beer license, you would be informed of that. That's how most people get informed of whatever regulations we have. It's the same thing as saying, well, I didn't know it was, Mr. Trooper, I didn't know that the speed limit was 55. I didn't know that. Well, that's not a defense in the law, not knowing it, because most people won't know that unless they have a particular experience that gives them that information. So, I sympathize with the situation, but when a person builds a home, and then in this case, Mr. King was actually building a home, 500 or 1,000 feet away, simultaneously pulled all his permits. In this cabin, for this particular cabin, he actually did pull a septic permit and an electrical permit, and Ms. Peterson's here, from the codes department to talk about that if you want to hear from her. But he was clearly knew that he was supposed to pull building permits when you build a home. People do, that's what you do. And when you go to the zoning department and you want to pull your zoning permit, that's when you find out that there may be special provisions. You might find out that if it's on 41A South, that is a scenic highway designated by TDOT. That's something that the county worked with TDOT to get done, and there are special regulations. Pay a lot of attention to the county's website, and you see what's posted in these agendas and whatnot. So that's the point. The other point I would try to make is that what happened between the Planning Commission and the County Commission in terms of how this was advertised, how this made it into the record once we, like I said, finished this autopsy that we're trying to do, for lack of a better term, that really has no bearing on what you guys do. You guys are trying to administrate a regulation that the County Commission passed, and you didn't have any part in that. You just have the book in front of you, you have the records in front of you, and you're trying to make decisions that you have jurisdiction to make. And I don't think it really has any impact on how whether the County Commission didn't advertise it properly, or whether the Planning Commission did or didn't. All those things really had no bearing on the decision you make. You've got the law in front of you, and you're just trying to make that decision based on what you have. And so I would just, that's the point I can make. If you want to hear from Ms. Peterson, she's here too.
Let me clean up so the minutes reflect. I would entertain a motion that we enter all of the previous record into the record tonight, so it becomes part of this. Since it is basically a new but we have all the topographical, the St. John reports, the correspondence and stuff. It, part of the, enter that into the record. I have a motion by Threet, second by Mr. Hart. All right, I'd also like to point out that we do have a letter from, Mr. William Culver, living on Moonbend Road. I'd like to make sure that gets it entered into the record as well. Do we have anyone else here that's a neighbor that, before we get started, I want to make sure we don't leave someone out before we get started. All right, usual procedure of this is,
Mr. Chairman, we actually had two letters, one from Kenneth Culver and one from William Culver. They're essentially the same content, but you have two.
thank you. I want to make sure both of those are entered, and I think those are in support of, and also questioning things. Staff, all right. Ms. Smith, do you want Mr. King go first, or you know,
Well, I think
whatever how you want to do this?
probably that is the best route to take. As I said, and cited a little bit of the comments from the, you know, I usually think my mouth is big enough and my voice carries enough that I don't have to have one of these, but I understand. I understand. There were some comments at that October meeting about the fact that Mr. King did not get a building permit. And in the record, the minutes, it states that his contractor was building the house. He didn't think he needed a permit for the cabin. He considered it to be an accessory building and was building it off the grid. And it's already been noted here that he was at about the same time building his residence. Mr. King and I have discussed that point extensively, and I believe that is the point that he wishes to address the board directly about. Mr. King.
Thank you, Ms. Smith. Mr. King, if you identify yourself for the record, please.
David King. First, I'd like to say thank you to Mr. Vick for making the motion to deny my cabin. It's got me back in church. I didn't realize how bad I have become. I had been out of church for 16 years, and I didn't realize how important church was. But this cabin shows how full of greed and how full of self. Got back in church and got a great preacher. Well, actually got two great preachers going to two different churches itself. But he told me we got to die of self every day. We got to pray to die of self every day. And I pray to die of self every second because I'm so full of myself, or I was anyways. But thank y'all for God's perfect plan.
I'll tell you what, that's one of the rarest things I've ever seen. Somebody come up and actually take ownership of something, so God bless you for that.
Thank you, sir. And I also would like to ask for forgiveness of my, I guess, my false testimony. The last time I was here, I guess was so full of myself and so far astray that I thought my half-truths were not a lie, but they were a lie. You know, I said I didn't think I needed a permit because I was off grid and you know, I didn't think I needed a permit because I didn't think the county could do anything. I mean, I have my own solar, own water. It's my property. That's all selfish thinking. And if I'd have got the permit, I wouldn't have been in this situation. I wouldn't have put y'all in this position. I ask for forgiveness, and I'm glad you're here, and I ask for forgiveness for I lied to you. I know I can't exactly remember exactly what was said, but I do know that now I started building this quite a while before the house. I don't remember the time frame, but I built this, or I had help building this cabin. I was so full of self that I didn't even tell my wife that I was going to build this cabin. And it wasn't going to be this big, and wasn't going, so that just shows how full of greed I was, just full of just, and I'm just, the only happiness about the whole thing is y'all denying me to break me to get me back in church, and it's sad that it had to take something like this to get me back in church, but I appreciate you so much, and God's great, and his plan's perfect, and thank y'all.
Thank you, Mr. King. That's gonna be a hard one to stop. Tamara. Let me point out, I appreciate that. We have to look at this in new light. We appreciate your input on that. Thank you, Mr. King. Tamara.
All right, so Mr. King, in talking with us, we devised a plan of action to come before this board and talk a little bit about this self-imposed problem. Now, after what he just told you, I don't know that I can convince you that he didn't have a hand in self-imposing this problem. However, the variance that he requested is the same variance, I believe, that was first brought before this board back on August the 21st. And that is specifically a variance from the Duck River overlay, which requires a 250-foot buffer, okay? So according to the engineering work that was done and the previous request for variance, he is seeking 195-foot variance on the southeast corner and a 220-foot variance on the southwest corner. In essence, he is asking for the variance after the building has been erected. It's about 95% completed. I do not intend to rehash the old the things that were done on the first series of hearings before this board, but I do want us to look a little bit at what is to be done for the zoning board's ordinance to be amended. Now, when Mr. King bought his property, he bought it in a couple of tracts, and that was in the 2014, 2015 years, and that was before the Duck River overlay was passed. Okay, and that was not until 2019. So the Duck River overlay came into being after he bought his property. And the ordinance itself sets out at section 8.100 how you go about amending it. And I included that in the package that Mr. King and I put together. And I know that you all have probably looked at it a million times for various reasons. And it sets out what has to be done to notify the public that there is going to be some amendments to the ordinance. And quite frankly, it gets pretty specific about, what the effect or what the amendment itself is going to be. Now, Mr. White has worked hard, and I give him credit for working hard at trying to come up with the records that I requested. at this point, what we have been able to come up with and look at simply do not address the Duck River overlay at all. And so when we ask tonight for a variance, and we're asking for that specifically because it is necessary because of the overlay, I ask you to consider whether or not he should have known about the overlay. What we know about the public notice is that there was a notice run in the newspaper, was very generic, very non-descriptive about the June 11th, 2019 meeting. There was nothing in there that would have alerted the public that it was about land on the Duck River. And nothing that has been produced since then gives us any sense of identification. Now, I know that Mr. King has self-confessed that he didn't do everything that he was supposed to do, but he did do a lot of things he should have done. And he did do them. When he wanted to build a boat ramp, and his whole purpose for buying his property on the Duck River was for his family and others to enjoy it. And the first thing that he considered doing and did do in 2021, and that was after the overlay was passed, he put in a boat ramp. And he knew that he had to file an application with TWRA and TDEC. And, you know, gosh, there's lots of acronyms going on. But, and he did do that. And in the packet that we provided, he is a copy of his application and the letter that he received and the information he received that his application to build that was accepted. Now, we all know that the Duck River is protected because it is a very valuable resource. And when he contacted TWRA and TDEC and got their permission to build, it is noted that they actually did a rare species, I guess, test, and to see if that proposed boat ramp would cause any harm. And their report indicates that it would not, according to what they came out and investigated, consideration of his application. So they let him go ahead and build his boat ramp. So it's not that he has just thumbed his nose at everything that he should have done, and he did a lot of things that he should have done. In 2024 is when he got really serious about building the lodge. And the first thing that he knew that he had to do was to address the issue of the subsurface sewage system. So once again, he applied to the proper authority, and they came out and inspected and approved him. And at no point along the way, and at this point he has no idea about the Duck River overlay, but nobody else raised the issue either. So he went ahead and got his subsurface sewage system approved by the state authorities. And to get that properly installed, he had to have an electrical pump. And so he applied to the Department of Commerce and Insurance in May of 2025 for an electrical permit for that property. Once again, filed the application. The proper inspectors came out, inspected the property, approved his application. Nobody talked about the Duck River overlay, and he proceeded on. I'm not going to try to add to or take away at all what Mr. King has said before this board. I believe he spoke from the heart. He didn't necessarily speak from a legal standpoint. but he spoke from his heart. I believe that the Bedford County's zoning ordinance itself and Tennessee Code annotated 13-7-105 set out certain parameters for changing an ordinance, a zoning ordinance, to protect the people that live in that area and that are going to be affected by it. Like I say, we're not here to point fingers. We're just here to say that perhaps from what we know today, there wasn't the proper publication, there wasn't the proper notification. And he did not know. It's conjecture for us to say that if he'd applied for a permit, he would have known. But we don't know that. We don't know that. In his application, and it was the supplemental comments, which was, I apologize, 6 pages long. We remind the board that the lodge does not do any harm in any way to the vitally important and environmentally sensitive resource known as the Duck River. We are simply asking that this board utilize the BZA's procedure for authorizing variances under section 8.090. And the purpose of that variance is to modify the strict application of the specific requirements of the resolution, the ordinance. In the case of exceptionally irregular, narrow, shallow, or street lots or other exceptional physical conditions. And I think that that's where the board addressed this issue the first time in, that it made a decision in October of 2025. Where strict application would result in practical difficulty or unnecessary hardship, which would constructively deprive an owner of reasonable use of his or her land. So I ask you to consider, what is reasonable use? He has practically completed building a river lodge for his family's use and enjoyment on the Duck River. And that's basically the only thing that that property can be used for. It's already been determined to be a constrained lot, and I believe the house is, the lodge is built in about the only place it can be built. And if he is required to tear that building down, then he is being deprived of any reasonable use of his land. The variance provision goes on to say that variances shall be granted from zoning restrictions such as heights, setbacks, lot density, where variances are reasonable and necessary to ensure unobstructed access to direct sunlight. None of that really applies here. But variances shall not be granted which would cause an unreasonable obstruction of direct sunlight to adjacent property, or a reasonable probability of utilization of passive or active solar radiation. None of that applies here either. The variance shall be used only where necessary to overcome some obstacle which is preventing an owner from using his property under this resolution. And that's the point that I want this board to hone in on. In applying the overlay provision to this tract of land owned by Mr. King, he is not able to use his property at all. The property can only support a subsurface sewage system where it currently sits. And for him to have to tear it down is just really going to cause what the variance was designed not to allow to happen. total ability to use his property. And that's where I ask this board to consider the issues that we have brought before you tonight. If you feel that you can't render us a decision tonight based upon the fact that there may be some records that have still not come to light, but I would say that there has been diligent effort to locate them, and there's not been any located. There were a lot of, I agree with Mr. White, there were a lot of other overlays and a lot of other amendments that were going on, but I'm concerned that the Duck River overlay was not passed in the manner that that the statute or this ordinance requires. But if we need to wait, I mean, I just want to reserve the right for us to continue to look for records if that's what this board thinks is the best thing to do.
Thank you, Ms. Smith. I would point out that, and again, I don't want to get ahead of ourselves, but in this case, I would ensure that whatever motion is made, if it's a denial, that the time for appeal will not start into the records that y'all jointly get to them. If it's 2 weeks or 2 months, whatever it takes, we wouldn't want to restrict that part of it to be a point. Because I see your point. That's and I think having whether it was legally passed is beyond our purview. But I think it's a good point for y'all to make. But I would encourage the board, if whatever decision y'all make, that the time for, I think it's 30 days, it does not start until those records are in your hands as attorney.
Or else some.
Or we say we can't find them.
That's right.
Okay.
Or unless I'm
A
notified that there's
resolution.
nothing
A
else to
resolution,
produce.
that has to be part of it. A resolution on that part. That's not fair to put a time frame that's not available to you, but that would be the point. All right, board?
I would like to hear Ms. Tamara Smith, the inspector that started all this, where this could have been stopped or started prior to this, for going this farther along. And she's here, I think, and I think all this information that we don't have could have come out at that time.
Miss Amy Peters, yes. If there's no objection, please. Very good. Please identify yourself for the record.
I'm
young lady.
Amy Peterson, Director of Building and Codes.
I just wanted to make sure when we started that and how we got to this point without not knowing what was going on.
Very good point.
What
Can you tell us when you first were noticed of this property, there was construction going on this property?
there was another house being constructed on I think at the adjacent lot. I don't have that handy, but I believe it was right down from it. And that particular, someone on that job site had alerted one of my inspectors of a house being built back down past their property. It's kind of hard to get to. It's very off the beaten path, but that there was being a building constructed down through there.
You'd had no knowledge of a house being constructed.
No, it's not a spot you ride by. It's not like driving down the main road and seeing it happen. It
And
is off in the
what
woods.
did you do once you were informed there was a house being constructed?
Once we were informed, we did a little investigation. So that's where it always starts, is investigating what's going on, seeing if we can tell. The first step is usually satellite imagery, and then also some images that my inspector took. He on the job site out. He went to the property to see what was going on.
What did the inspector find?
A fully erected building, a cabin, in its finishing stages or thereabouts. It was definitely past. It's past the point of when we do our inspections. From the time, say, insulation is done to final, there's a long period in that time frame, and it was somewhere in that phase.
So when you say a cabin, how large was the structure that you saw?
It was pretty large. I don't know the exact measurements of this cabin, but just it's based on the photos. It was no small shed, so to speak, cabin. It was a very large, rough timber frame from what I saw from the images.
And you went inside and inspected it?
I have not been on site.
Did an inspector go in?
Yes, Blake went on site, and my other inspector went on site.
Could you explain, Blake, what you saw inside this cabin?
I mean, I guess it was a little overwhelming because you're going through the woods and then you're looking for a little cabin, and it was pretty massive. And It was just built on a slab. I think it was 40 by 80 or 30 by 80. It was a really big slab, and it
Was there a
built
kitchen in
well
it?
Nice. There was a kitchen.
Is there a
were
bathroom in
bedrooms.
there?
Yes, sir.
Is there granite countertops in there?
Seems like there were.
Is there bathrooms in there?
Yes, sir.
Is there an overlook to the river on it?
Yes, sir.
Was it finished in a treated wood fashion, or was it just rough cut?
Well, our outside was kind of rough cut.
Would you describe it as being a little cabin in the woods?
I would love to have it.
Do you have an estimate about the cost of this?
I can't
Struck-
imagine. I mean, you're definitely over $500,000
Would it be over $1 million?
once it's finished.
So $500,000 to $1 million. Did they ever come to your office to get a building permit?
Did not.
So there's no way this office was ever aware anything was going on except someone saw you on the side of the road and said, hey, somebody's building a house down there, and that's the first you got.
That's correct.
Hey, did they have an electrical permit, an application for electricity?
Once I started my investigation, so the state publishes their electrical permits, their septic permits. The septic permits are published with photos where they go on their site. The state inspector always takes a photo of the site, I guess maybe to show what's there and what's not there. If I remember correctly, I believe that when he did one of his septic inspections, there is, like, you can kind of see at an angle, there's a structure in the picture. So that added to my investigation that something was there. We have access to some Vexel imagery, which is state satellite imagery, and looking at that to see changes of when construction started. You know, you kind of follow through different years of the satellite imagery and see clearing happening, you know, foundation being laid, that sort of thing.
So you don't know what kind of electrical wiring is in there because there was no inspection done. You don't know
No.
what kind of plumbing
I
was
will
in
add,
there.
we do not do any of the electrical inspections. The state
But
does.
the state does
yeah.
electrical inspection.
Plumbing, our standard inspections for a slab home would be, before the concrete's poured, we do 2 inspections. That would be under slab plumbing and the pre-pour slab prep. And then we do a rough framing inspection. We do in-wall plumbing inspection. We do mechanical inspection, pre-seal to make sure all penetrations have been inspected, and then insulation, and then final.
But you never did that.
None of those have been done.
40 acres, 40 acres. Zoned A1.
This is in a, this is,
Is the house on the same property as the cabin? Is this one piece of property or 2 separate properties or what?
So he owns 2 pieces of property. The house that he was building is on 1 parcel, which is also a sizable parcel. And then this 40-acre parcel is where he had the cabin, and the septic system actually was, I don't know, 1,000 feet long or something like that. I mean, it's 1,000 feet away. And it was actually, the drip dispersal area was actually on the other parcel, which we don't allow that either. So, because we don't allow septic easements. But I did talk to him, I did talk to Mr. King after we had the initial meetings, and I'm like, at least one thing you should do, if you haven't considered it, is to join those 2 parcels together so that at least that takes that issue out of play. And I don't know if he's done it yet or not, because we just now come back. But we had, you know, we gave him a pretty decent extension because he lost his first attorney. His first attorney told him that he's not a litigator and this is going to require some litigation. So he was left without an attorney. His attorney fired himself, and so that was a problem. And we definitely, because of the issue and because it's a big issue, we wanted him to have adequate representation. I think you guys did too. And so at every step of the way, we'd try to ensure that he had adequate representation. And then once he talked to me in January, because I'd given him a timeline, you know, and he had to contact me by January to get to either give me a reclamation plan or something that we were going to go through. And when I contacted him, he actually talked to me again and told me about the situation with his attorney. And so I recommended immediately that he try to find him another attorney. And that's when he ended up finding Tamara and Jody. And so once we met with Tamara, we realized that we needed to give them more time and give her time to really sink her teeth into the case, because in order for her to help him, she really needed to have some time to look into it. And so now here we are about to, wrap this thing up. But yeah, we just always wanted to make sure that he had adequate representation through the whole process, because this is a big lift. It's a heavy lift.
Is it not true that the whole overlay of the Duck River is all agricultural on both sides of it?
The overlay affects the Duck River 250 feet on each side of the river, everywhere in the unincorporated parts of Bedford County, just not in any of the municipal boundaries.
So what would Tennessee say about this?
Well, I mean,
we're setting an example for everything up and down Duck River. This is the key purse, right? This is the hub of everything that happens up Duck River, politically and everything else, the development, I think.
So I do know that the Harpeth Conservancy, which sits on the Duck River Watershed Planning Partnership with me, they are interested in taking our overlay as a model and trying to pass it everywhere in the watershed. Of course, that's going to require a legislative act on the part of every county commission in the watershed, 7 counties. And so then part of what the Duck River Watershed Planning Partnership is trying to do is create a set of standards and opportunities to take whatever good things come out of all these engineering studies, and what we're trying to figure out about the Duck River. We're trying to take those to all the watersheds across the state. At least that's what the state wants to do. And so I do know that they're interested, and the partnership is very interested in promoting a very similar model to what we have statewide. Because the river is now is on the threatened list, and 250,000 people get their sole source for their drinking water for 250,000 people in the watershed. There are endangered species of mussels. Like, for instance, whenever the TWIA come out, and one of the things they were trying to do is determine whether or not there was an immediate threat to probably mussels or endangered plant, because there's endangered plant life in the Duck River as well. It's the most ecologically biodiverse river in the Western Hemisphere. And so it's a big deal, and Governor Lee has had a big push to try to do something to try to protect the river and preserve the river. The watershed itself, as far as how we get our water in the Duck River, is pretty small. The Normandy Reservoir is not very big, and the area that drains into that reservoir it's not very big, so it's a very limited ability to capture water and then to deliver it all the way to the Tennessee River, because that's what it does. And there's a lot of other people that have straws in the water, and they're getting their drinking water out of it as well. And so we're working through these processes to try to identify places where we can try to preserve more water and protect the river itself. There's been a lot of threats to the river that most people are completely unaware of, that I will tell you is pretty scary once you learn those things. And so part of this overlay was, once we found out that it was on the threatened list, it was a concern, and we really wanted to try to do something and have some leadership role in trying to create something that we felt like would do our part to lessen the strain on the river. Now, getting down to the meat and potatoes of this thing, I will openly say, at the end of the day, what you guys choose to do is what you guys choose to do. If you find a way, or if Tamara has made a good case, we're not personally invested in this because it's done. I mean, the impact that house is having on the river now is probably negligible. It's just that while he was building it, it probably had a major impact on it. And most of the endangered species of mussels and things are further downstream between, say, Chapel Hill and Columbia, in the shoals area, not in the deeper waters in Bedford County. We don't have a lot of that in Bedford County. But what happens in Bedford County ends up in those places. So the turbidity of the water from all the siltation, all those things, it clouds out the sunlight. It affects plant species, which affects oxygenation in the water, which affects the fish and everything that's in it. And so it's a great thing to have, in all that, but at the end of the day, if you guys found some way or that you could live with to help him, it's not personal to us. We just don't want to set a precedent that people can just do it and then come back and get a variance willy-nilly. We want it to be taken serious, from that perspective. But I will say, just like Ms. Tamara said, what's done is there now. It's not creating an impact on the river now. It just had to have been, you know, when we look at pictures of it while it was under construction, the whole riverbank had
So
lost
you don't
all
know
its
what,
foliage.
you don't know what damage had been done.
Right now, it's not causing any problems. If we make him move that house, it's gonna be a mess.
I agree.
All joking aside, it's gonna be a mess. You talking about polluting the river, it's gonna pollute the river.
I agree.
Why would it be a mess? If the concrete pad stays, it doesn't come up. How far is he over the variance line?
195 feet on the southeast corner and 220 feet on the southwest corner.
So, may I interrupt? So is the structure 30 foot from the water? Or is that, how far is, like, from the edge of where the slope starts?
I think it actually says, it uses a term where the normal high water is, not necessarily water's edge, but where the, not flood stage, but when it's at its normal flow. And there's a term for that, because sometimes it spreads over and, yeah, repairing, I think the repairing, it is measured by the ordinance, I think, from the riparian zone. Thank you. I had a hard time with riparian. I'd like to point out that those are good points that you made, that whatever we do to say, oh, it's wrong, tear it all down, will probably cause more damage than what's already. I think if that enters those issues when we handled this the first time, that we considered that in that. And I think, are there places where someone could build, I'm going to use the term, a bluff view of the Duck River, and that may be something we have to allow mitigation then to prevent it from occurring, silt fences, whatever. Pretty robust. But those are things down the road. I think we have to focus on what our issue at hand here is, and they're simply asking, in the simplest terms, they're asking for a variance, and we've got a lot of previous information and a lot of points here. The point is whether the ordinance is valid or not, I don't think needs to enter into our, that's something beyond our purview. I think we have to handle, and I think within our judgment is your point. Are we causing more harm by not denying it and say tear it down than we do, or come up with some mitigation scheme that, and I think all that's within our scope. We've got pretty broad scope as long as we use reasonable judgment, and that's up to y'all.
At some point, if I may, I'd like to make a few more comments. Mr. King and I have discussed what can be done to remediate, to not cause any other further damage, to try to come into compliance with what needed to have been done during the construction, and he is willing to do those things. Whether we can back up at this point and get some inspections done, I know it's really hard to inspect something that's covered up with a slab of concrete.
Our role is solely decided on this role, so until that's decided.
And any kind of protections that need to be put in place, Mr. King is amenable to. So, you know, if we know what those are and can premise a decision on those things being done, then Mr. King will cooperate with that and ensure that no further damage is done.
So basically, we have a 40-acre tract with one perk site. Is that correct?
It's not even really on the 40-acre tract, it's on the other tract, yeah. The lot is definitely constrained. I think it's more constrained than we even know.
I think this is more than a variance. It's an example of what goes up down this river from now on out. It's just the future. The variance is immaterial, really, and what he can do, what he can't do. I think this sets an example for the whole Duck River, counties above and below, that pay attention to what Bedford County is doing. It's sad it's here, but it's glad that we set an example for the best of the, Duck River. Whatever that
And
may
maybe
be.
the example in this particular case, maybe if you guys impose some sort of financial, not a fine to go to Bedford County, but some sort of donation he would make to an environmental group that loves the Duck River. You know what I'm saying? Something like that, where it's not just it's not just a slap on the
I
wrist.
think that's beyond, and I think we have to be careful. That is something beyond our purview. You get into trouble when you start, as I think that going back to Mr. Sam saying, when it's, what does he call it, zoning roulette or zoning poker, that, we don't need to get into that. That's, I think, in your judgment, do we need to come up with a plan for mitigation? Is that the way to approach this and come back with a plan?
Yes, but I'd want him to hire an engineering firm to do the mitigation plan, so that it's done at a professional level, and then that there's some way for us, some metric that we can use in this inspection process. It's not just us looking at it, eyeballing it, that kind of thing.
And then possibly he could also, you're saying if you don't want to give it to conservancy, maybe on the bottom riparian zone, that he could talk to the same engineer, what he could do down there to help clean the water in that area, because there was a lot of orange dirt that came off of there.
Yeah, filter strips, other things,
Right.
other mitigations you make to that long-term,
That was done in the
long-term
process of building.
long-term relief to accomplish the goal of what I think we're trying to do with the overlay. Then let's look where we are. Either, and I don't mean to be blunt, but the easy things, turn it down and go home. But that's, we still have the problem still there with the Duck River.
One of the things I would like to bring up, and Chris, maybe you can help me on this, are there not plans to stop within the range? One of the things is commercial logging, how far away from the river? And this new things coming up.
That's a good question. I mean, as far as the overlay is concerned, we would apply that to commercial logging as well, just on our end, because we don't want to disturb the riparian zone, which is the area that protects the river. It sort of filters out siltation and all those kind of stuff. And you cut down all those trees, if it floods, a lot of those trees end up in the river, and they create log jams, and they tear things up, and it's a big deal. So, but is there a state law or something you said is coming down?
I read something recently about what the point I'm bringing up. A lot of landowners save their timber for their retirement. And if we're coming up with regulations that they can't cut it, it creates a problem from a agricultural standpoint. It's just that simple.
Honestly, I think that if it's an agricultural property, it would be exempt from any zoning regulation if it's ag. And
Well, then let me ask you a question. We got 40 acres sitting out there. Is that not agricultural property?
no,
Well, what is it?
it's zoned agriculture. But
It's keeping holding the rest of the world together, because
yeah, it has no agricultural value. It's
And you
basically
can put a
surface
fence
level.
around it and run all the goats you want to on it.
Well, you could do that. I mean, it could be used agriculturally. It's not being used agriculturally, but it could be.
I'm telling the truth. It's just that simple.
yep.
It depends on And you sure don't wanna do this, but you can put a pile of hogs, you can put goats, you can put sheep, you can even, you see my point, especially if you're feeding them. But we need to be real careful we don't trump. When you say agricultural, it covers a world of different things.
It does. I'm dealing with that
And
right
those
now.
of us that own that agricultural land are having to fight to keep it that way.
Yeah, I agree, and the way that we handle it, of course, the agricultural zoning, you know, is really, the protections for the farmer is really about the zoning part of it, which would include the overlay. It doesn't have anything to do with building, and so it doesn't have anything to do with flood zones. Of course, he's not in a flood zone, but so the not getting the building permit is an issue regardless that needs to be resolved. But from the agricultural point of view, you know, farms are exempt from all of our zoning regulations, so it's a good point.
We're here. Somebody make a motion, we'll argue over the motion. Or discuss a don't make a motion, discuss a motion. Let's see if the balloon floats.
Very much amenable to having an engineering study on how to mitigate any further damage and to protect what is actually there at this point.
Thank you, Ms. Smith. I got the easy job. I don't have to make motions.
I would like to have discussion on the point.
Discuss framing your motion,
Yes,
Commissioner Three.
Discuss framing a motion. From a standpoint, this is agriculture. I know he didn't get the permit. I'll be the first to say that. And he was wrong in doing that. But at the same time, what's going to happen here is going to be a precedent set down the road. And we need to keep that in mind. Don't we, lawyers?
I think the only argument that appears to be, which is a very compelling argument, is that the lack of notice on the Duck River overlay, and that is out of the purview of which we were responsible for having. All we have is the record. We can only look at the record, and we are structured with only limited things that we can look at. And unfortunately, this does not meet the criteria that rises to the fact to give a variance in there, and I can't come to that I've tried to come to the conclusion to find a way to get the variance, and I cannot get there. And as compelling as the comments that were made earlier, I'm applauding the courage to stand up and make comments like that in a public meeting. We've got a job we have to do, and we are restricted in what we can and can't do, very specifically. So I would have to be my motion that we do not accept or we do not grant a variance. We submit the entire record here to the for the record here, and that your alternative or your remedy is to go to Chancery and seek remedy in Chancery. And perhaps there is an avenue that Chancery has that can interpret it differently than what we have, or may agree with your argument there. But I just can't get there on giving them a variance. So that would be my motion.
Okay. I have a motion.
Second.
And I have a second from Mr. Hart. I'd like to point out, I think this is exactly where we were in October. We agreed that it was constrained, but as we looked at the circumstances, we couldn't see a clear vision to grant the variance, even though we saw lots of issues that were going to cause more harm. And I think that's, so your reason, and I think your reason is exactly the same you expressed over 6 months ago, that we don't see a clear view for us to grant this variance because of the way that our ordinance is structured. And is that, did I? Okay, I'd like to add to your motion, and second, if it's agreeable, that the time for appeal will not start until the full record provided by Mr. White and with agreement of counsel is provided to them. At that point, the clock stops. So if it takes whatever time, that way we're not constrained by time.
And I accept your amended motion.
Will you accept it? So I have an acceptance by the motion, my motion and second.
I think this was a preventable situation, very presentable. I mean, very preventable. But to set the example for the state of Tennessee and Bedford County, because there's other counties looking at us saying, we're watching to see what they do. And that's a whole lot involved in what this passing thing just to get stuff done. I think it's an example for Bedford County that we care what we're doing. And that's just my opinion.
All in. Any more comments? Is the motion clear? Is we clear in the motion and clear with the accepted the seconds? Is that clear enough for legal purposes? Did we meet the criteria there, Ms. Smith? Okay. All right. Are y'all ready to vote? The motion is to deny the variance for those reasons stated. All in favor?
Aye.
It passes unanimously. There were no nays. Next item on the agenda, I think we have a review. Mr. White, have you had any discussion for our bylaws?
No, it's just that we're required by law to do a review every year in case any of you take any issue with the bylaws that are, as they are currently printed. Staff doesn't have any issues with it. It's just that we're required to bring it up every year.
I know there was earlier discussion as far as time limits. Are we still comfortable with what the procedures that we use presently?
The currently adopted procedures are exactly what we were going to recommend anyway, so.
All right. Any further things for this board?
Which is 3 minutes per person, total of 30 minutes.
But also at the discretion of the board by vote, or the chairman can extend that if we see that it's really interesting and we want to hear more. Okay. I'd entertain a motion to adjourn.
So moved.
Well, everybody, that's a unanimous motion by everybody. All in favor? Aye. We're adjourned.
Decided to postpone our wastewater meeting to another time. So to inform the public, that is our decision. And I'm glad y'all got a tough job to do.